prosecutor isn't dropping the charges, negotiations have broken down, and your trial date is set. What can you expect? Today we're going to take you out of the crowded courtroom and talk about the criminal trial. A criminal trial is broken up into 6 parts: jury selection, opening statements, direct examination, cross-examination, closing arguments, and jury instructions. Every trial begins with jury selection. You'll pick a jury later that morning or in the afternoon. When the trial starts, the judge will give the jurors some preliminary instructions. Then the prosecutor will give an opening statement. An opening statement is the prosecutor's story of what he or she intends to prove. Your attorney then gets to get up and tell the jury your side of the story, including the lack of evidence, conflict in the evidence, and evidence that your attorney intends to show at trial. After opening statements, the prosecutor will call their first witness. They can call as many or as few witnesses as they like. They can call them in any order that they want to. This is called direct examination. During direct examination, the prosecutor will ask open-ended questions like who, what, where, when, why, how, and the witness will tell a story. After direct examination of that witness is done, your attorney will get up and conduct a cross-examination, where he or she will ask close-ended questions, yes or no questions that start with isn't it true or didn't you? Once your attorney is finished with the cross-examination, the prosecutor gets to get up one last time and ask some more questions that are based on the cross-examination questions. This is called a redirect examination. After the prosecutor calls all of his or her witnesses, the state will rest. Your attorney will ask for a judgment of acquittal, which basically means that the state hasn't proven its case in the light most favorable to the state. These motions are rarely granted. Your attorney will then put on his or her case. Sometimes your attorney will simply rest and not present any witnesses or evidence. Remember, it is the state that has the burden of proof, of proving that you're guilty beyond a reasonable doubt, so you don't have to prove anything. But many times, your attorney will want to put on witnesses, exhibits, or other evidence. After your attorney presents your evidence, your attorney will rest your case. Your attorney will renew the motion for judgment of acquittal, and then both sides will give closing arguments. The prosecutor will go first, telling the jury what evidence he or she presented and how that evidence establishes your guilt. Your attorney will then give a closing argument by telling the jury about all of the conflicts in the evidence and testimony, the lack of evidence presented by the state, and the evidence presented by your attorney and how the state has not proven that you are guilty beyond a reasonable doubt. Finally, the prosecutor gets the last word in a rebuttal argument where he or she can respond to everything your attorney said. Once the rebuttal argument is over, the judge will read the jury instructions. The jury instructions are the rules and the law that the jury is bound by. After the jury instructions are read to the jury, the judge will send them back into a jury room to deliberate. Then, in secrecy, the jury will talk about the facts and the law and decide whether you are guilty of the charged crime, guilty of a lesser included offense, or not guilty. The jury's verdict must be unanimous, meaning that all 6 must agree on the verdict. There are 12 jurors for capital cases. If the jury cannot agree on a verdict, the judge may declare a mistrial and reset your trial for a later date with a different jury. If the jury comes back guilty, the judge will either sentence you immediately or more likely will pass your case for a sentencing hearing at a later date. If the jury comes back with a verdict of not guilty, you will be released with no sentence, court costs, or any other punishment.